Okay, good evening, everybody. Welcome. We're really delighted to have you here. Just to say a few words of welcome, I want to introduce our director, our executive director, Professor Frank Frady, to say a few words. So, Frank.
Good evening, everybody. This is our first event. Can you hear me at all? Because I can really shout. It's part of my job description to shout all the time. This is the first event we have in the new season, and it's an important event because one of the big issues of our time is the law and the right and just position of the law, the relationship between the judiciary and political representatives is a constant source of conflict and friction. And today, it's much more important than ever before because so many decisions that are taken by political representatives are often negated or rendered void by the courts. So we live in an era where all of a sudden, lawfare has become really, really important. And I think the discussion tonight for us at MCC Brussels is one of the first on this particular topic. Over the next year, we're going to be continuing to explore and examine the relationship between the judiciary and the political system. We're going to be looking at things like the independence of the judiciary and the tendency for what we call the juridification of society, whereby the courts impose their authority upon political decision-making. So, welcome. I hope you enjoyed the discussion, and many of you will also take part in it. And just remember that in terms of intellectual refreshment, MCC Brussels is here to provide you with stimulation and, in a sense, to challenge the ideas that you have. And over the year, there's a lot of events that we'll be organizing, and I hope to see as many of you as possible in the next few months. Thank you.
So, thank you, Frank, and again, welcome everyone. I'm Jacob Reynolds, the Head of Policy here at MCC Brussels. Really delighted that you joined us, and if you were with us at our last event of last season, you'll probably find the entry to this event a lot more calmer and a bit smoother, so we're very grateful for that. But it raises, obviously, a series of important questions about the variability of us at MCC Brussels, and more broadly in Brussels, the possibility of there being debate and discussion, and lots of these issues that we were grappling with at the tail end of last season were obviously brought into very sharp relief by events in America and the awful assassination of Charlie Kirk. And it shows that the problem, the hostility to speech, debate, the right for us to have an open and frank conversation about the issues facing us in America, in Europe, and across the world is one that we have to fight very, very hard for. So we're delighted to better continue offering this opportunity for people to raise important questions and discuss difficult issues. Now, obviously, the immediate context for tonight's event was the now famous letter of several European leaders, which raised questions about the degree to which the European Court of Human Rights had begun to overstep its remit and interpret the treaty in a fashion that was out of keeping with its intent. But there is, as Frank alluded to, a much kind of broader and longer lasting context to tonight's discussion, which is the fact, the repeated sense over many years and in many, many cases, both in the court in Strasbourg, but also in national courts, that a kind of cluster of, if you like, legal innovations by the Strasbourg court had made action, especially when it comes to matters related to migration, very, very difficult, if not impossible. And if you're not a lawyer or a specialist, some of the terms that are invoked will sound kind of strange to you, such as living instrument, dynamic interpretation, the use of Rule 39, the idea of extraterritorial reach, and a whole other series of legal innovations. We'll discuss a few of them tonight, but to note that we released today on our website, which you can go and find, and there's a code on the leaflet on your chairs where we released a paper where we attempted to demystify some of this language and state in plain terms the tremendous kind of powers that the court had granted to itself to interfere in matters of sovereign democratic countries. And it's very important that we're able to have a discussion about this because I think, certainly in my life, and I'm sure for many of you as well, and maybe my fellow speakers, to raise any questions about the evolution of human rights law is almost immediately shut down with all kinds of abuse and the fact that you're kind of want to bring back the world of 1930s Germany and all the rest of it. But it's actually very possible and very necessary to raise the question and ask whether the intention of the human rights legislation and treaties that were signed in the wake of the Second World War, whether they're both fit for purpose now and whether they've expanded their reach in the meantime. And tonight's discussion will focus a lot on the role of the ECHR, but it's really one of a cluster of treaties and obligations and courts that have come to make dealing with matters of migration, but also a whole other range of issues very, very difficult for the nation states of Europe and beyond. So to dig into these questions, I'm really delighted because we've assembled what I think is a really wonderful panel for you tonight, but also we have a great audience, I'm sure, so we'll dig into this with you. But to briefly introduce our speakers, and of course, the very important people with longer biographies than I have time to go into. But sitting closest to me is Mark Berset, who's Professor Emeritus of Law at the University of Antwerp and President Emeritus of the Belgian Constitutional Court, among many other titles. And if you follow the news, you'll have noted that Mark's been very prominent in the last few days and weeks following a memo that he circulated regarding how to deal with the politicization of the courts in Belgium and beyond. We're also going to hear from Luc Gittos, who's sitting furthest away from me. He's a lawyer and a writer. He's the author of a brilliant book called The Human Rights Illusory Freedom, Why We Must Repeal the Human Rights Act, which is the piece of legislation in the UK which gives effect to the ECHR. And we'll also be hearing from Bernadette Petrie, who's a ministerial commissioner for directly managed EU funds. So can we give our speakers a warm welcome? Before I ask Mark for his opening thoughts, I do want to stress once again, we are MCC Brussels. We believe in open and frank discussion. We're looking forward, after some short opening remarks from our speakers, to lots of questions and comments from the audience. And I know there'll be people with a variety of views sitting here. In fact, I'm certain of it. So we do welcome a big discussion and debate, and we look forward to getting it stuck into it with you, because we do think that open and frank discussion is very, very necessary. So with that out of the way, looking forward to hear what you think. But first, I'd like to ask Mark for his opening thoughts.
Well, happy to be here. Thank you for the introduction. I think, as you said, the starting point is the letter signed by 9 leaders of EU governments, and the reactions on that. The reaction was that immediately 15 academics, Belgian academics in Belgium, criticized the letter. It was the end of the rule of law. And the Prime Minister was questioned in the Parliament, and he was so good in replying to the opposition to refer to my book. And that book is Right to Asylum Between Demagogy and Hypocrisy. It was originally in Dutch and then in French, and now it's in English since this year. And myself, I reacted to the letter of the 15 academics by defending the letter. And that was published in La Libre Belgique of the 30th of May of this year. Now, to understand my criticism, you have to know something about my background. I am a professor of international law, specialized in the international protection of human rights. That has a United Nations site and a European Convention on Human Rights on the other hand. And I have been for 9 years, but that's already a long time ago, from 87 to 97. I was in Belgium, the first Belgian Commissioner General for Refugees and Stateless Persons. The Commissioner General for Refugees in Belgium is the independent administrative authority determining who is a refugee and who is not. So that I did for 9 years, and that explains my interest for the subject, and particularly the influence, the tremendous influence the Court of Strasbourg has on asylum policy in Europe. How does that come? Because in the European Convention on Human Rights, there is no provision on asylum, not at all. There is no right to asylum. Even in the other international human rights convention, there is no right to asylum. It's only mentioned in the Universal Declaration of Human Rights of 1408, and that is not a legally binding text. But it is in the EU Charter of Fundamental Freedoms. That's the only place where you find a right to asylum. Now, despite the fact that the convention does not mention a right to asylum, the court is dealing with it gradually. And the basis for the case law of the court on that issue is Article 3. Article 3 is the prohibition of torture and inhuman and degrading treatment or punishment. That is the starting point. Now what did the court do with that article? Well, it started already in 1973 with a Moroccan who has been executed, and with the case of Söring, which is very well known. It's a German citizen who did kill his parents-in-law or future parents-in-law. And, well, he said, if you send me back to, from the UK, if you send me back to the United States, I will stay for a long period on death row. And that is inhuman treatment. And the court was going along with that, and it said, no, you may not extradite that person to the United States. And that was in 1989. Now, in 1991, we had the first asylum cases before the court. It was Sweden wanted to send someone to Chile, and the UK wanted to send a few people to Sri Lanka. And there the court said, well, because the prohibition of torture is absolute, it has extraterritorial effects. And so a country that sends someone to another country where that person runs a real risk for treatment, contrary to Article 3, that country is indirectly responsible for that treatment. So that is really the basis of the case law of the court. But the court went even further, because I think everybody will agree that you should not send someone back where that person runs a real risk for capital punishment or a real risk for torture. But the court interpreted torture in a very broad way. And it said, and that's the judgment of 2011, MSS, it's against Belgium and Greece. There the court said, if you, Belgium was condemned for sending someone back to Greece, because that person there, someone from Afghanistan, the person there would risk bad treatment. He was ill-treated for 4 days, and then he was left at his own. And so the court said that the absolute prohibition of torture extends also, it's not only a prohibition of doing something, it's also the obligation to do something, and the obligation to provide a decent asylum procedure and a decent reception for asylum seekers. Now, I contest the fact that this is also as absolute as the prohibition of torture as it was originally conceived. And that is a problem, and I think we should try to work on that aspect of the matter. Other problems with the court are the interim measures. It's not only the court that from time to time you have a judgment, and then now we have seen the press unit of the court say, well, only 1% of the cases are dealing with this, and so what do you complain? The problem is not that 1%, the problem is mainly the interim measures taken by the court. And that's based, you said it already, in Article 39 of the Rules of Procedure. So the court can intervene, and by doing so, the court intervenes in the daily management of asylum cases. And a huge number of those interim measures are taken in matters of expulsion or extradition. And the basis for that is really weak, because in the European Convention on Human Rights, there is no provision on interim measures. We have this in the American Convention on Human Rights, we have this in the Statute of the International Court of Justice, but it is not in the European Convention on Human Rights. Moreover, over the years, there were proposals to make those measures binding, because in its initial case law, the court said interim measures is a recommendation, but it's not legally binding. So suddenly, in 2005, in a case Mamad Kulov and Askarov, the court said, from now on, it became binding. And so this was criticized by the minority, well, only 3 judges in the minority, and that said what the court is doing there, it's an excess of power. And I sincerely believe that is really true, and that's also a major problem, those interim measures. Now finally, another area in which the court is complicating matters as far as asylum law is concerned is in the procedure. In the convention, there's nothing on procedure, and in the Geneva Convention, there's nothing on procedure. The Geneva Convention only say you may not send someone to his or her country of origin when that person fears for persecution, fears for his liberty, for his physical integrity, or for his life, because of some reasons such as political opinion and so on. That is the Geneva Convention, nothing about procedure. In the European Convention, you have Article 6, fair trial, but the court said it does not apply to that. You have Article 13, effective remedy. There should be an effective remedy in case someone complains about the violation of one of his human rights. And there the court said, yeah, that remedy, it should not be necessarily judicial, but it should be suspensive. So as long as there is a period for appealing the decision, and as long as there is no decision on that appeal, that person cannot be returned to his or her country of origin. So that is also complicating matters, but it has been even more complicated by the EU itself, who made in the Charter of Fundamental Rights, it said it's a right, and if it's a right, you're entitled to a judge. And in the directives adopted already from 2005 on, it says that any asylum seeker should have a possibility for appealing to a judge. Now that is also complicating matters. Now, I accept that you need, it is justified in my view, to provide for a judge, for the possibility of appeal to a judge in case someone is sent back to his country of origin where that person fears for his life, liberty, physical integrity. But in my view, it should not be with anything connected with an asylum application, in particularly when an EU member state decides to transfer someone to another EU member state. In my view, that should not require a judge. That should not require a judge with suspensive effects, particularly. And I think that's something maybe we should try to work on, because if I take the example of Belgium, we're not doing well in asylum for the moment because we're too many, and some people are sleeping on the streets, so it's not the way it should be. But the main reason is that we suffer too much from secondary migration. Secondary migration is people that came in by another country, another EU country, and they should be dealt with by that other EU country, but they come to Belgium because for one or another reason they think it's better here. They're mistaken, but they do come. And I believe that all this should be much simpler, because I don't think that we should accept the idea that within the EU we torture people. I don't think we torture people, so this Article 3 should not have extraterritorial effects. There should not be indirect responsibility, and I think it should simplify the matters much, because we have in Belgium 40% of all asylum seekers should be dealt with by another EU member state, but before we can send them back, we have to deal with that. We have to offer reception facilities to them, and we have to give them the opportunity to have their case examined by a judge. So that is the introduction of 10 minutes you asked me, and I will stop with that. Thank you.
Thank you very much, Mark. We'll certainly get on to another thing that we need to get your thoughts on, Mark, about what necessary we should do as a response, because obviously that's one of the things you've been very much in the press about. But to move on for the next of our introductions, Luke, I'd like your thoughts.
Sure. Thanks, Jacob. I wanted to talk rather selfishly, if I may, about the situation, the political situation in the United Kingdom. Jacob mentioned in his introductory remarks that it has for a long time been politically forbidden to talk about reforming the UK Human Rights Act or to interfere with our relationship with the European Convention. But I think the UK is interesting precisely because I think that situation is changing. I think it's becoming increasingly mainstream in the United Kingdom now to recognize that the expansive approach that judges in the European Court have taken is at odds with the national interest in the United Kingdom, and that we are losing democratic control over some rather fundamental areas of our political life. This has been most crystallized, I think, recently with the decision relating to the Conservative Party's Rwanda policy. For those of you that don't know, the Conservative Party, whilst they were in power, formulated a policy which has largely reflected policies that had been adopted by other countries and has since been adopted by other countries within the EU, to deport or to remove asylum seekers to a safe third country prior to their application for asylum being determined. And that safe third country was Rwanda, set up under a bilateral agreement. And as Jacob hinted at in his introduction, a judge at the European Court of Human Rights took an interim measure to stop those flights to Rwanda taking off, because there was a risk of the rights of the migrants on that plane having an interference with their convention rights. And effectively what that did was stop a democratically elected, a democratically passed policy of the UK government from being enacted. And I think that was a moment of quite dramatic sea change in the discussion in the United Kingdom. Flash forward a couple of years, and you now have some rather mainstream figures in the United Kingdom coming out and saying that something about our relationship with Strasbourg needs to change. And most recently, this was encapsulated by Jack Straw, who, for those of you who don't know, was the new Labour Home Secretary who was key to bringing the Human Rights Act into our law in 1998 under Tony Blair. So it was a significant moment for him to come out and say that the European Court of Human Rights had gone too far, was interpreting rights too broadly, and that something needed to change, and would not even rule out the possibility of leaving the convention entirely. It's not just Mr. Straw, though. We now see some mainstream commentary in the UK, particularly amongst lawyers and particularly liberal supporters of the Act, recognizing that, particularly in the context of Article 8 and the right to a private life, something needs to change. So the UK is an interesting context. It's worth remembering that Keir Starmer's government is going to be facing off against Reform, the Reform being a populist right-of-centre or right-wing party in the United Kingdom. And Keir Starmer is going to be facing Reform opposition on some very marginal seats. And Reform MPs will probably be arguing for the UK to leave the convention entirely. And it's going to put any Labour MPs in those seats in a very difficult position if they are forced to defend the Human Rights Act outright, precisely because there has been so much in the UK media about the limits on democracy that the Act allows for. So there is a lot of active discussion that we can go into in the question and answer about precisely how a country would leave the European Convention and what the impact on the European Court would be if a country did leave. But I think for the second part of my opening remarks, I wanted to say something about why I think it is politically important for us to leave. Because I think the central unresolved question at the heart of our discussion on human rights is who controls the parameters of our freedom? Is it the people, the populations of our European nations, or is it an unelected and unaccountable judiciary? And I will defer to my fellow panelists to discuss the nuances and machinations of the European Court of Human Rights. But I think that fundamental philosophical and political question has never gone away since the convention was drafted. I remember when I was writing a book about this topic, about 10 years ago now, I went through and read a lot of the dispatches from the Council of Europe, where the European intellectuals that were responsible for drafting the convention came together to talk about what the role of the convention should be, the convention being the European Convention on Human Rights. And it's worth remembering that they were very explicit that any European Court of Human Rights had to sit above democratic pressure. Their view was that certain areas of political life should be beyond democratic contestation. And in preparation for tonight, I was going back and reading academic writing from in human rights textbooks and human rights journals in the 1990s and the early 2000s, just before the UK passed the Human Rights Act. And human rights proponents at that time were repeatedly explicit about the need to curb democracy, and they saw human rights as a way of limiting the influence of the nation state, and often saw it as a way of moving beyond the nation state. They saw it as a wider program of limiting democratic control. And I think why leaving the convention is important is that we would, in a small way, strike a blow to that mode of governing. Because I think what's become highly pernicious in the UK context is what we might call rule by lawyers. Rule by lawyers involves the law taking the place of politics in the resolution of democratic questions. An old, I shouldn't call him old, an ex-Supreme Court Justice, Lord Sumption, very prominently called this law's empire. It's the involvement of the law in areas of political life that it was never intended to become involved with. And I think what we have seen in the second part of the 20th century is a growth of litigation in areas of public interest. We've seen the growth of the human rights lawyer as an area of practice, and that's just a commercial reality in London. You've seen the growth of more and more human rights law firms, more human rights chambers. You've seen greater deference to the European Court in matters of high-profile political concern. And I think all of this gives rise to a parallel system of political accountability. What I mean by that is that decisions taken by our representatives are no longer judged about whether they are politically right or morally right. They are instead judged on whether they are lawful and whether they meet our international obligations. There are innumerable examples of this in the UK context, and I'd be very interested to hear about the European context as well. But to conclude, I would say that those who want to leave the European Convention on Human Rights can't see this merely as leaving a single piece of international law. This has to be part of a broader program to place control over the fundamental questions of our political life back in the hands of our elected representatives. This is about returning decisions around the parameters of our freedom back to those we vote for and taking the power back from those we don't vote for. That needs to be the broader political project that is entailed by leaving the European Convention. It's no longer a legal question, it's fundamentally a political one. I'll leave it there.
And Bernadette, your opening remarks.
Thank you so much, and I'm very grateful for this invitation. And one would ask a question whether this topic has anything to do with the directly managed EU program. The answer is obviously no. However, I'm a lawyer by profession, and I would like to create a more broader context to this question, and also cover what, for instance, happened in case of Hungary and Hungary's migration fine, because I think that that case describes very well the situation. So first of all, I would start that it is important to, or worth it to introduce one phenomenon that is posing increasingly significant challenges, and I used to call this juristocracy. It is kind of aristocracy of a certain circle of lawyers who are just overtaking the power of different democratic organs. And I think that the ECHR itself is a great example for this. However, we also have to cover the ECG, because that phenomenon can be also learned by experiences of the ECG. So, since 1999, the European Court of Human Rights, whose powers were strengthened by a protocol, has been issuing hundreds of decisions every year, 99% of which are based on complaint by individual citizens or NGOs against their own states, right? But on the other hand, these are mostly NGOs that are local branches of global NGOs, so the entire thing is an NGO system, an NGO network. And often they are funded by American foundations that are settled in Central and Eastern European states, such as Hungary. So I'm really truly talking by experience. On the other hand, lawsuits are brought by NGOs here, and instead of real judges, we can see that the 47 members of the convention, it is actually the Strasbourg judicial apparatus, the so-called registry lawyers, which is occupied by global NGOs, and they are deciding on human rights lawsuits against states. So that is the current situation about ECHR, and here the important momentum is the appearance of these NGO networks. From a legal perspective, I would say that for many hundreds of years, the principle of, and I will say this in Latin, the jus speciali derogat generali, the special overrides general, that served as a guideline to the Western law itself. But now with the appearance of this kind of judicial decisions, it has been changed. Today, based on the most general constitutional principles and fundamental rights, this has been completely reversed, and even if there is a precise rule to something, even if there is a law or there is a regulation, it can be set aside, reinterpreted, and decided upon the opposite way in light of the most comprehensive constitutional principles and fundamental rights. So what happened? There was a Roman law principle that was guiding the Western democracies, and now it has been reversed, and more is influenced by political will. I truly believe that in the field of migration, it is worth to see the situation with the ECHR to understand this juristocracy, because we can see how harmful often these decisions are. So extending the right to a standard of living makes repatriation particularly impossible. Then the ECHR has also ruled that the protection of rights is mandatory not only within the country's territory, but also outside if the state exercises control. Therefore, and that's the consequence of this, that any ship detained at sea or camp outside the border, for instance in the case of the Italy-Albania agreement, is automatically subject to Strasbourg control. Also, the extension of the right to effective legal remedy in the event of mass migration places a huge administrative burden on states and can also prolong procedures for years or even more. Furthermore, according to the court's interpretation, in certain situations, the refusal of a humanitarian visa may also violate the convention. So these elements make the entire current migration system, and we are not here to decide on whether that is functional or not. I think that the European system is rather dysfunctional, but absolutely impossible to operate normally. But in order to see clearly what happened in case of Hungary, let's just take a look at what was the basis of the migration case that has resulted in Hungary having to pay a daily fine of 1 million euros. In 2018, and I dig into my notes because it was complicated, in 2018, the European Commission brought legal action against Hungary because, in its view, Hungarian rules and practices did not comply with EU asylum and rules and return directives. The Commission leveled 3 charges against Hungary, and the most important one was the transit zones in Röszke and Tompa. Hungary kept asylum seekers in transit zones, and the Commission considered that the conditions there were unlawful detention. Here, the interesting thing was that in 2019, the Grand Chamber of the European Court of Human Rights ruled in another case, in the Ilyas and Ahmed versus Hungary, that staying in the transit zone in Röszke is not constituting deprivation of liberty because the applicants were able to return to Serbia. Consequently, they said that it is not an unlawful detention. So we have one court saying it was an unlawful detention and other courts saying that it was not. And at the end, and as a consequence of the ECG decision, we have to pay this huge amount of money per day, which is, I think, anything but legal certainty. Well, I would go further. In case of the ECG, I think that the situation that has been just described by the other speakers is potentially less bad, but there are similarities. So, for instance, the judges have greater influence over the apparatus here, but, for instance, the opinion of the advocates general often influence the judgments. Then, in addition, the phenomenon described by revolving door analogy, which refers to the mutual interchange between the ECG and the European Commission mainly, but also other EU institutions, is of particular importance. So once they are sitting at the institution, and a few months later they are sitting as a judge at the ECG. There are certain examples on this. Furthermore, the inner circle of judges from the old member states excludes delegates from the newer ones often, and they're trying to secure all the important cases for themselves. So we can see that there's a certain level of, I'm not saying unlawful, but from the democracy's perspective, not useful cooperation between the institutions and the court. And this brings us to a situation where political decisions and political intention is overriding the legal system and the law itself. So I truly believe that this phenomenon is one of the most significant drawbacks of democracy, but I have to tell you that this can be not just experienced at the courts or the ECHR or ECG, but also at the European institutions. A prime example of this is an immunity case just from yesterday, where European Parliament's Legal Affairs Committee made 3 politically motivated decisions. But we can also recall the case of Marine Le Pen, for instance, and see how politics can override the law and the legislative frames. At the end, I think that we might have one other example from the Patriots group, and it is important to mention this, because the case how the European Parliament is trying to introduce another legal showdown, as usual, is the procedure against the Patriots, where they are trying to generate law case that has nothing to do with the Patriots group, but they are collecting cases from the past of another group, Identity and Democracy, and these two groups has nothing to do with each other from a law perspective. And they are saying that since there are a few members who were also sitting in Identity and Democracy and they are also sitting in the Patriots group, then the Patriots should be responsible for these cases, and as a consequence of this, the money could be drawn that is given by the European Parliament. So I think that in this case we can really and truly see that often not even a violation is needed to introduce a legal action, but they can also find somewhere cases from another legal entity. So here we can arrive at a stage where the question that we can pose, who is governing Europe? Because if judges influenced by political agendas claim the final word over the elected will of the people, then democracy is hollowed out from within. And I'm a Hungarian, so we Hungarians know from history what this means, and we know from our past that this situation can have heavy consequences. And in order to defend democracy, and this is mainly the topic I would like to raise in this conversation, we have to somehow stand up against the rule by judges, because this goes against democracy and this goes also against legal certainty. If Europe to remain democracy, the principle must be clear. The people, through their elected representatives, must have the final word. And I would conclude that, well, let us defend democracy not only against threats, but also against the creeping internal usurpation of judicial power. The future of Europe is depending on this. Thank you for your attention.
Okay, in one moment I want to come out and get some questions and comments from the audience, but I just wanted to give the panel a quick chance to both reflect on things that the other panelists will have said, but also to get onto this question of kind of what ought to be done about the problems that have been outlined. So, Mark, I know you've been, as I say, this has been the topic of much press discussion, your suggestions on how to get through this, and I know that's where you might, for example, disagree with Luke slightly.
No, what I would like to say, I'm not in favor of withdrawal of the convention, what means I would like to prevent it. But I am convinced that if nothing changes, it will happen. It has to change. It cannot go on the way it's going on. But if possible, we should try to prevent that. Now, as far as the UK is concerned, it's not new. I want to remind people a speech given by David Cameron before the Parliamentary Assembly of the Council of Europe in 2012. And he said, well, sometimes we're confronted with a terrorist and you cannot try them, you cannot detain them, and you cannot expel them. You should help us and find a solution for that. Up to now, no solution has been found. And another point, maybe some people don't know, is Madame May, who became Prime Minister, was before she was Home Secretary, what do you say?
Yeah.
Home Secretary.
Home Secretary.
Home Secretary. And she was in favor of leaving the convention. She was not in favor of leaving the EU. Now, what did happen? They did leave the EU and they didn't leave the convention. So it did happen the other way around. So that is, I understand fully the British position and the British problems. Now, the Hungarian lady did speak about Ilyas and Ahmed. That's, I think they are, in fact, in the proposal I made, and maybe I should explain it later, I would like the court to come back only on two judgments. The first is MSS versus Belgium and Greece, and the second one is Ilyas and Ahmed versus Hungary. What did happen in Ilyas and Ahmed? It was two Bangladeshi came to Hungary, and Hungary said, inadmissible, back to Serbia. And then the court said, well, you know what could happen? Maybe they will be sent from Serbia, North Macedonia, and then, oh horror, to Greece. So apparently the court was more concerned about those two Bangladeshis being sent to Greece than being sent to Bangladesh. Because we all know, those who are familiar with asylum, the recognition rate of Bangladeshis is very, very low. Thus the chances that they would be recognized as refugees were practically nil, but they could end up in Greece, and that should be prevented. No. And so in my view is, there is a rule in the EU law, and it's called mutual trust. It's the principle of mutual trust. Every member state has to suppose that another member state does respect its international obligations and the EU law. Now, this judgment, MSS, is contrary to mutual trust. There's no mutual trust. We may not trust Greece. So I think that is, in my view, definitely unacceptable. And I think even that we should extend the principle of mutual trust to all state parties to the convention. So not only to the 27 EU member states, but to all. Why? Because I try to explain that because prohibition is absolute, prohibition of torture is absolute, you have extraterritorial effects. And because you have extraterritorial effects, you have indirect responsibility. Now, what I would say is that within the EU and within the states parties to the convention, there should be no extraterritorial effects, and there should be no indirect responsibility. So if we could get this adopted, maybe as a protocol to the convention, then the court would be bound by that, and then we could prevent withdrawal of the convention, I hope.
Yeah, and Luke, I wanted to come to you because the question about withdrawal or reform or whatever, I wanted to give you a chance because in some ways, some of the best arguments against actually meddling with the treaties or even withdrawing from them is the fact that the situation is so bad that the local level judges or national level judges themselves have kind of not just through case law adopted many of these aspects, but also internalized the whole system. So it is also just a necessary first step, even if you wanted to leave. So could you say a little bit more about the broader politicization of the judiciary?
Yeah, well, just firstly, dealing with the question of reform or repeal, I guess Mark may be able to explain to me how this might work, but the proposal that comes from the liberal supporters of the Act in the United Kingdom is that we would pass some kind of piece of domestic legislation which would somehow steer the UK judiciary away from an expansive definition of, say, Article 8. So you would have a piece of statutory law that effectively diverted in some very severe way from the current UK Human Rights Act, which simply introduces an obligation for judges to take the decisions into account. So there would be some kind of domestic law that steered our judiciary in a particular direction. The reason I can't see how that would work is what happens if a country like Italy, for example, wanted to pass a piece of domestic legislation that allowed them to depart from the decisions of the courts where it came to matters, for example, of asylum or in matters of, so for example, the case that you referenced in your document, Jacob, the case, I think it's called Hisram in Italy, a fairly recent case in which Italy were effectively held liable for expelling refugees that they had rescued at sea. And the European Court of Human Rights found that once the rescued migrants were on the Italian vessel, they were subject to Italian territory and were subject to the relevant legal obligations. Of course, placing the Italian government in an extremely invidious position because suddenly they're faced with the prospect of both rescuing people from the ocean as they are dying and then becoming under the burden of having to process their applications for asylum before they can be removed, which seems to me completely bizarre. But it does also raise a question about to what extent national governments can influence the trajectory of the court. Is it that we could say that Italy might pass a piece of legislation that would prevent that happening again? The reason why I think that's a very important question is that we have to remember that the European Court of Human Rights was set up in order to resist such democratic pressures. It's designed to make sure that it can't be susceptible to these kind of measures. So I think even if you passed a relatively modest piece of domestic legislation that says we can depart in these circumstances, doesn't that set a precedent, so to speak, across Europe that undermines the entire normative project of the European Court of Human Rights.
Great. And Bernadette, your reflections on what can be done? Should it be a kind of reformist approach, or do we need something more radical?
Well, I see that this entire problem of the politicization of the law and this kind of decision could be handled or prevented by an appropriate legal framework. And I see that this is actually a practice in almost every European country. So what is happening at the level of the ECG or ECHR or at the level of the EU institutions are not unique cases, but if we go through the decision-making in all countries, we can find very similar examples. However, I see that currently the political willingness is not really following this line, and it is really very useful for the EU institutions, for instance, that there is this politicization practice of the ECG, for instance, and they can just foresee that it is a partnership of two different organs. The European Commission is saying that it is great that the ECG can take these politicized decisions because it is good for the integration, it is opening up certain principles, it is softening the legal framework of the EU, it is guiding us to the even closer union. At the same time, the level of the ECG, as I said, even from an organizational perspective, there is a very close cooperation with the Commission. For instance, DG Justice used to regularly have informal settings and meetings with ECG judges. So, but the direction is going to the on the wrong way, because currently each reform I can see, for instance, in the European Parliament, documents circulating on the future of ECG or their financing is just causing even deeper problems on that, because it is enhancing the politicization of the ECG even further. So at the end of the day, I truly believe that somehow a proper legal framework should be set at European level that is stopping this, and one of this is revolving door, where it is really easy to intervene. So this one you can stop very easily, but the more complex questions could last a bit more time.
Okay, great. We've got lots on the table, but I'm very interested to hear some thoughts and reflections from our audience. So please stick your hand up if you'd like to speak. Jamie, if you could take that microphone to the gentleman standing. Well, who's got the other microphone? Yes, my colleague Philip has it. So take that to, there's a gentleman there. So firstly, you, and then you. Yeah?
Yeah, thank you. First, thank you, Frank, and the MCC for opening again your doors for this very inspiring soiree, which has not been sacked yet by the Brussels Antifa. Maybe I can challenge you to bring you one step further, to leave your footnotes and bring you more to parliamentary artillery. We started with saying that 9 out of 46 member states of the Council of Europe signed the letter, which makes, if I'm quick in my mind, something between 90 and 20%. The question is what we are doing to make it more. Everyone is laughing about this letter. It has no impact at all, because 9 out of 46 does not make a difference. And politics is about mathematics. So who are the one in its own member state? I know we have a friend from Finland here, Lito, I don't know where he is, to lobby in the member states to bring more signatures. And the second question is very concrete. Next week, on the agenda of the Parliamentary Assembly of the Council of Europe, in charge of appointing judges at the court, we have a new file with a recommendation from Hungary. So Hungary should bring a new judge to the European Court of Human Rights. The left majority at the Parliamentary Assembly of the Council of Europe is blocking this. awaiting the next general elections in Budapest next spring, hoping to see the Orban government fall and to appoint then leftist judge. What is the action we can do now? What can we conclude to avoid this and to make sure that the judges are from our side, if ever already the court is politicized?
Yeah.
And this third point is, I recommend a very nice study of my dear friend Gregor Popank in Strasbourg, who analyzed the bio, the CV of the judges and their assistants. And he came to the conclusion, just by scrolling through the CV, that more than needed come from the Open Society Institute. So they had a special training. They have a special network of the left. And my last question is, what are we doing to have our network there? It's a good fight. If they have their network, where is our network? Thank you.
Great, thanks. Hopefully we'll get a chance to reflect on that. So there's the gentleman in the back. Could you bring, if you want to speak, can you put your hand? You have to remember the lights are very bright, so I can't necessarily see you unless you actually put your hand up. So there's a gentleman at the front, Jamie, if you could get. We'll get this gentleman, then we'll get this lady, and then we'll get some comments from our panel, okay? Just start speaking and they'll make sure it's on.
Yeah, thank you for the very erudite panel. I was thinking I have a kind of inborn reflex when the right wants to introduce more legislation or abolish or draw out of old legislation, that it always gets used against them. Very recently, the NVA in Flanders has shown how this works. They tried to introduce new legislation which was actually used, meant to be used against secessionist movements, being mostly Islamic movements and so on. But it only got used against the native population of Flanders itself. It's the same with the UK. The UK they voted for Brexit. A lot of people voted for Brexit so the UK could become sovereign and so they could defend themselves against the migration waves. But we saw afterwards that there was only more migration and that this drawing out of the EU didn't really help them. So the basic heuristic of our liberal progressive elites is, at this point, for my friends, everything, and for my enemy, the law. They exempt themselves from the law. We saw it with the Black Lives Matter protests. And their client groups, they will exempt them from the law and they will use the full force of the law against their enemies. So my question is, wouldn't it be possible that stepping out of the ECHR will be mostly to the detriment of native Europeans? And can we ask the question whether or not changing laws is at this point relevant, or if we need regime change, the people who are behind these laws to change itself?
Great, thanks.
Thank you.
So we'll take this gentleman, then this lady, and then we'll get some comments, but come out again.
Thank you so much. I really appreciate Professor, the way he explained. It was really amazing. If I better understand, the European Court of Human Rights was created right after 2 years after the United Nations Human Rights. So there was not too much clarity. As you said, Article 3, it is misusing, and they are extending their power. No, it is after 75 years. Let's have a look. The United Nations Human Rights, they keep eyes on USA, and the European Court of Human Rights, they keep on Europe. But let's see in USA. They are different states, different countries, different needs. New York and California, they are immigrant-friendly states. It is acceptable. It's very acceptable for the human rights for United Nations. Similar, they are Texas. That is not very friendly like New York to the immigrants. So what I want to say, here in Europe, the Belgium, it is very friendly for immigrant, right? But, and Holland, of course, Germany, yes. But this is not the case in Holland, not the case in Poland, Hungary, and Romania. But this is not very acceptable by the European Court of Human Rights. I think this is very unfair. There in USA, Trump can send back 1,000 people at once, but here in Europe, even one people cannot be sent. Even if we send, there will be a big noise by the European Court of Human Rights. Okay. I think this misuse of power should be stopped, and there should be set of rules like if there is a friendly country list, if someone is coming from there, it should be deported, and that should be considered with the European Court of Human Rights together with the governments. Thank you so much.
Okay, thank you very much. Right, one more question at the front, and then we'll get our panel to respond.
All protocols respected. I'm so touched with the idea of immigrants and those that are dying in the sea, on the sea. I'm part of them. I'm from Africa. And my question is, it is very rhetorical. How can it happen in the 21st century that Africa is still paying the price? We paid the price for slave trade. We paid the price for division of Africa. We're paying the price for dying on the sea, and Europe is doing nothing about that. The world is quiet. The world is silent. The young generation is silent. And my question is, no matter the legislations that are laid in various European countries that will help you welcome them, many have died, many are drowning. Is it going to continue? Are we going to bury Africans on the dying sea, on the drowning seas? Do we sit here and just talk about that and nothing is being done? So I'm here with a broken heart and talking on behalf of the voiceless. Let Europe arise and save Africa. If it takes Africa for Europe to survive, it should take Africa for Africans to survive. Thank you so much.
Thank you. Okay, so lots of questions. I don't expect our panel to better answer them all, but Mark, you might want to take the cluster of questions about what can be done to make the balance of power in the Council of Europe more favorable.
Well, I will only answer some of the questions asked. The first point was important for me was about 9. I think we should not mistaken about that. They started with 9. I've been told now there are more than 20. And 9 is not 9 of 46, it's 9 of 27. Huh? So one didn't even, those others, non-members of the EU, but parties to the EU, didn't have the opportunity at all to sign that letter. And I think the mood in Europe, and in the world maybe, is such on this matter that have never been more optimistic than today, that maybe there is a possibility of changing the system this way. Because the system is murderous. The system is provoking the death of thousands of people in the Mediterranean. There are even people dying now in the Channel. That should stop. And asylum is too much a matter of smugglers. Who determines who comes to what country? The smugglers decide. It's not the people themselves that don't know. And I don't think we should cooperate with a system that makes smugglers very rich, that make migrants die in the sea. That is not a system that we should support. The last comment I want to make is about the domestic law and so on. Of course, changing only domestic law will not help, because the court will say it's contrary to the European Convention, and so that doesn't work. So the only way, in my view, is first, we should try to adapt the interpretation of the Convention, maybe by adopting a protocol that gives clear guidelines to the court which would exclude the jurisdiction of the court on certain issues, as for instance the transfer within state parties to the convention. Then, if we do so, we have to modify the EU legislation, because the EU legislation is entirely based on the case law of Strasbourg. So there's a lot of work to be done in adapting again. Unfortunately, we have this new pact coming in next year, but the EU legislation has to be adapted. And only then we can expect that the national judges also will adapt themselves. Because the problem is not only the judgments of Strasbourg, the problem is that our domestic judges apply the judgments of Strasbourg. And so the only way to get them change their views is to change the EU law and the European Convention.
Great, thanks. Bernadette, there's plenty for you to pick up on, so I'll let you.
I would react on two things. One is that you have mentioned the Antifa attack. And I would like to just raise that yesterday in the European Parliament there was a decision on immunity cases, and among them there was the case of Ilaria Salis. Ilaria Salis was beforehand an Antifa activist who has been put on the German Greens list in order to be elected as an MEP to have immunity right. And now the European Parliament's Legal Affairs Committee decided not to suspend the immunity rights of this person who in Hungary attacked randomly elected people. So she elected people by how they are dressed, thinking that they are fascist, and they attacked them physically. And it was a huge case in Hungary. And the European Parliament said that in Hungary this is a politically motivated legal procedure against Salis, and therefore this immunity right has not been suspended. If anything, that this is a legal decision that is influenced by politics, and it is very, very bad for the credibility of the EU. Then secondly, on the appointment of judges, yes, we had the same situation with ECG at the last election, by the way. So it used to be a modus to somehow try to bring in a leftist judge from Hungary instead of a right-wing one. And I told you at the beginning that I'm not going to talk about EU programs, but now I do, because what came into my mind that judicial trainings. There is a huge program in the EU budget from the Citizens and Rights and Values program that goes on judicial training, and the consortium leader is Open Society. So it is pretty obvious that the values the judges are getting by this training are very much influenced by Open Society's values. So this is where we are. And unfortunately, the frames of the budget frames of this fund is almost 1 million euros. So it is a huge amount, and I think that's very sad. They are making this training obligatory in most of the judges who are dealing with, for instance, detention cases. And I think that this is not really helping European democracy.
Great, thanks. Luke, you might want to take specifically the question whether it's kind of pointless just leaving given the regime that exists among judges. But
yeah, I think just starting on this question of progressives versus the rights use of law, I think there is a good historical reason why legal activism is primarily, I think, at the moment, a tool of the left. Because the legal activism that we have today, I think, has its origins in the United States, particularly in the civil rights movement. And when I talk to self-professed sort of activist lawyers, they will describe the decisions like Brown and Board of Education in the States, in which the Supreme Court mandated the racial mixing of schools in the United States as a starting point for an industry that then developed very quickly around public interest litigation. And they tended to be around progressive causes because they saw themselves as lending support to progressive movements in the United States. What I think we have often now is that largely the same groups of people in many respects. In Europe, lawyers, elite-minded lawyers in Europe and in the UK, have effectively carved out a sphere of progressive influence using the courts. And if you look at, you can chart the emergence of various different NGOs from the middle of the 20th century, and these are the NGOs that are now playing a very formative role in the decision of the European Court of Human Rights. So if you look at both the decisions around the Rwanda scheme, and then if you look at the decisions around Italy and asylum, the people that are providing evidence to the European Court often are the very NGOs that grew out of the progressive lawfare, which has its origins in the United States. So there's this very interesting movement from America into Europe. And it's still a lot more active in America than it is in Europe, because the US Supreme Court is far more capable of bringing about social change than the institutions in Europe, because the Supreme Court can strike down state legislation, etc. So I think that's the historical reason why progressives have historically been probably more prominent in their use of the law than the right have. But I really want to echo Mark's point about humane asylum, because I think if the Italy case tells us anything, it shows how legalism, in other words, adhering to the letter of the law, can cause absolutely inhumane consequences. Italy was faced with the prospect of people drowning in front of them. What they did was rescue those people and took them back to Libya. And it was found to be unlawful because they didn't process their asylum claims properly. A completely inhumane, ridiculous position for us all to be in. But it's precisely because these instruments of international law exist that we can't take the issue of asylum on in national legislatures and craft a more humane system. If you read decisions of UK tribunals which deal with asylum cases, they are pages, and often 70, 80 pages of impenetrable law, which very few people in the British public can understand. And we are mired in this. We are mired in our international legal obligations to such an extent that we can't take a step back and say, what is the humane thing to do in this situation? What's the right political thing to do? And I think picking apart the political project of asylum from our international legal obligations, which so often lead to inhumane outcomes, would be a really good first step.
Good. Okay, we've got time for some more questions, so do stick your hand up if you'd like to intervene in the debate discussion. Yeah, so there's this gentleman here who's helpfully stood up so I can see him. Is there anyone I can't see? I'm sure there must be more people, given that I did look at who registered, and I know some people won't necessarily agree with what our panelists are saying.
Thank you very much. Can you hear me?
Yes.
I want to continue on what you just started and this comparison with the US, because this is something I had in mind as well, and you brought it up. Essentially, I think we should try to continue the comparison. We know that now the situation has changed in the US, right? We have a more conservative court, which is more in favor of originalism, judicial restraint, constitutionalism. And the question I had is, do you think that this is a prospect that is possible in Europe? Could we have maybe in 50 years in Europe those very same courts, but dominated by conservative judges or judges rather in favor of judicial restraint? And I think this also echoes the previous question. What are we doing in order not to only influence the law, but also influence the legal background, the legal ideology behind those lawyers and the judges? And I think, and I'm really curious to hear your answer, but I think that one of the aspects that distinguish the US on the one hand and the EU on the other hand is that almost by definition, a judge sitting in a European court needs to be of this current ideology. Because one aspect you didn't touch upon is that not only these judges are going towards more leftist agenda, let's say it briefly, but also they are going towards more power for them, for the EU level, for judges, for non-political bodies, as you say, and less power for the national level and for political bodies and not judicial bodies. This is ontologically linked to the EU as a project. So and as a matter of fact, we could say the day that we would have European judges not necessarily always going for the most European solution, we will be able to say, okay, finally Europe is a mature political project, because they won't feel the need to go for this always more Europe, more EU solution, less national, and it will be a bit similar to the US with a more mature political system. So I'm very curious to hear your views on this aspect. Thank you.
Great, thanks. Yes, there's two more people who wish to speak, so if we get the microphone over there, in fact, so we got 3 more people to speak, so 2 at the front and 1 at the back. Jamie, could you run the mic to the back? And I think there's 2 people at the back who wish to speak and 2 people in the middle there. Go.
Okay, excuse me, sorry, thanks very much. There's been a lot of talk about activist judges, which I have a lot of sympathy with. I think it's a significant problem. But I haven't heard so much talk about rights. And since we're talking about the European Court of Human Rights, our understanding of rights and how that has changed. Because it seems to me that it's not just a problem of activist judges, but also culturally, our understanding or how we think about rights has changed. So, whereas, for example, I might say a right to free speech is really important. I'm now struggling. I think democracy is very good, but for me, the number of rights there are seem very, very limited. And what we consider to be things that are important in life, like we would like people to have a good standard of living, we'd like family life to be good, have been turned into rights. That seems to me to relate to the expansive definitions that you've been talking about, is that culturally, we've got this idea that you have a right to all these things, which actually, are they rights or things that you've got to earn and fight for, but not rights?
Great, thanks. So there's the gentleman towards the back who's got the microphone. The microphone that was with my colleague Tony should be passed along, but we'll first go to the back.
My question is, with how Europe is now becoming more and more politically divided, with some governments being elected in some countries that are more right-wing populist and question the situation in regards to migration, which Europe has taken in the past decades, and some countries elected governments which are in favor of status quo. So my question is, with this division, is it possible to find a compromise on a legislative and judicial level? And if it isn't possible, what should be done so that a compromise could be found? And my second question is, with the threat of chat control being passed in the EU, should people be worried? The people who are skeptical of the current migration policies, should the people who are skeptical of those policies be worried?
It's a very good point that I would be amazed if the Strasbourg court, which is so often ruling about the right to privacy and the right to it has anything to say about the proposed laws that would see everybody's messages capable of being read by EU officials. But I'd be surprised. Anyway, so there's this gentleman here, then there's my colleague at the back, and then we will, I think, go to the panel for some closing comments.
Yeah, thank you for your talk. I wanted to connect my question to that of Tony and shift from the more legal aspect to the cultural aspect. Because we can all observe the persona of the activist judge, right, as well as on the national level, as well as on the European or international level. There was it's still ongoing, actually, a very infamous case in Belgium of Dries van Langenhove. I won't go into too many details, but basically the reasoning of the judge was that she gave him a quite severe punishment to serve as a kind of an example for society. And in my mind, this goes completely against the rule of law, because your function as a judge is to measure within the framework of the law what someone's punishment, if any, needs to be, not to make political statements. This is something that we saw in Maoist China, for example. So there's a certain psychology behind these people, and I agree that we need to get in more of our people in these positions, but then again, that doesn't mean that those other people vanish. They will stay, they will try to exert their influence and their power in another way. So my question is, shouldn't we also focus, besides the purely legal stuff, on the cultural battle, on the fight for cultural hegemony, changing people's ideas about the nature of rights? What is a right? Why are we so focused on rights? How is it possible that, for example, non-citizens, it appears to me, sometimes are better off than, or better protected by all these laws than citizens, for example? So there's a cultural mentality behind that. Shouldn't we also focus on challenging that in the cultural sphere? Thank you.
Great, thank you. Okay, so I think that the final question will be one of my colleagues at the back of the room.
Yeah, so it was nice that we spent this lovely evening so far criticizing the ECHR and activist judges and the industry of human rights lawyers. But you don't have to be that old to remember that it was exactly the opposite when the political left was very critical of these institutions. In fact, 10 years ago when I was back in university, I defended, a member of the Conservative Students' Union, I defended the ECHR against an activist green professor and a radical communist student in a debate. So I think it's a bit hypocritical that after a decade, when the political left outsmarted the political right and won basically every legal battle in these institutions, now we are complaining against the institutions. I think it's much more important that we come back and outsmart the political left again and beat them again, and we retake these institutions as they have done again with the other way around against us in the last decade. So that's basically, I think, we need to be better again and not sound like complaining. That's the key to win this issue.
It's one of the great pleasures of working at MCC Brussels is that I completely disagree with my colleague on this question, but that we're still on the same team. So, but anyway, to wrap up then, some closing thoughts. There's plenty that we really need to address here. I don't think we've really nailed the question that was actually raised there and by a few people on what our relationship should be to these international institutions, given that they do exist. We've got plenty that we can cover on the specifics, but I'd also like to reflect as we close on some of these cultural issues that have been thrown up about, is this really actually a discussion about the law and about judges, or is it a broader political, cultural discussion that we need to have too? So in the order that we did our introductions, but Mark, your closing thoughts.
First comment is on about what I believe is in the highest courts, and that's constitutional courts, Supreme Courts, and international courts. The division between judges is between judicial restraint and judicial activism. That's a reality in nearly every court, but the balance can be different. Now, another point I want to make is when I'm criticizing the court already for 50 years, but so that means from the third judgment on, and there are 26,000 now. But when I did so, well, people were not happy with that. They said, you may not criticize the court. Huh? You may not criticize the court. What I see now, that even governments now dare to criticize. That's new. Before, no, you may not do so. It's not correct to do so. But a new development I see is in the United States. So suddenly, those people that said, you may not criticize the Court of Strasbourg, no, they criticize the US Supreme Court. If you may criticize the one court, you may criticize the other court. So I think, to a certain extent, we made progress because it's not forbidden anymore to criticize court decisions. On the other hand, a small comment I would make, in my view, the Strasbourg Court is already somewhat more cautious now than 15 years ago. It has been worse. For the major judgments we had in asylum was in 2011, 2012, and so on. Those were terrible. You have less terrible judgment, but of course you cannot change. It's very difficult to change the case law of a court, very difficult. On those rights, one of my criticism on the court was that the court did not make a distinction between classical civil rights, liberty rights, and social rights. I think it should be done. And the court has always attributed more positive obligations. They read into those obligations where those rights were formulated in a negative way. So that's a point of criticism I have already for a long time, and I don't know whether you can do a lot about that. On the compromise, the possibility of a compromise, I see two possibilities. First, of course, I said it already, if the court will not change, you will see withdrawal. And that, I think it's not good. We should try to prevent it, but it will happen if the court doesn't change, and they should understand that themselves. And second, there is something new coming again, and that's the idea of the EU becoming a party to the European Convention on Human Rights. It has in fact been blocked by the Luxembourg court because they were unhappy with asylum decisions, and they were unhappy with the non-respect of mutual trust. So this is also where you have some room of maneuvering. I would say if you don't change your legislation, your case law, the EU will not become a party to the European Convention. So it's a possibility of pressure. And my last word will be, we're speaking here about Strasbourg all the time. Don't forget Luxembourg, because they're not much better than Strasbourg. Thank you.
Thank you very much. Benedict, your closing remarks. No, we can certainly.
Yeah, I would continue this logic because I fully agree with it, and I don't really can give you the answer on the more abstract questions, but I can give you the answer on how we can intervene to stop this from an easy perspective. Well, I think that ECG in its practice, for instance, should respect the treaty in the sense of, and I tell you a few examples just to a bit describe the current situation. So I don't think it is normal or it is good for the rule of law that the one of the current judges of ECG was the Deputy Director General of DG Competition, and now dealing with competition cases. So this is showing the revolving door phenomenon is being a great dismantle, a great drawback for democracy. Then there are other examples. I won't just tell you all of them, but for instance, some of them are members of board in civil society organizations that are often suing at the court. There is another one who resigned and 20 days later was already a member of a legal office that is representing clients at the ECG. So this is just abnormal from the true meaning of democracy, and I think that this could be easily sorted out. And this is why I'm saying that if the treaty would be respected and the internal rules, because there are certain rules on ethics, there are certain rules on giving a certain cool-down period for judges, but they are not respected and it is without consequences. So they are easy manners of intervention, but somehow it is not in the political interest of some people in this elite.
Great. Thank you very much, Benedict. And on this topic, final thoughts go to Luke.
I have to say I thought I'd be fighting an easier battle in convincing people that we should, especially people on the right, that we should be leaving the European Court of Human Rights. I didn't think the position would be that we would restack the court with right-wing judges. It seems to me that that's, firstly, a completely fool's errand. When you're dealing with the US Supreme Court, the process of appointing judges is obviously politicized, explicitly politicized. And you're dealing with a dispute when it comes to judicial interpretation, which is quite clear and stark, i.e., do you use the Constitution to reflect the situation of your current society, or do you reflect what the founding fathers believed and thought when they wrote it, i.e., originalism? It's difficult to see how that would easily translate to the European Convention on Human Rights, and for the obvious reason that it's a far newer document and far more expansive in its reach. If you look at the way that the European Court gives rise to all sorts of pseudo-law and all sorts of guidance and regulation, it's very difficult to see how you would exactly replicate that politicized distinction in the context of the European Court of Human Rights. But as has been hinted at, the process of attempting to roll back the decisions that you don't agree with, we're talking about 23,000 decisions, many of which it would be very difficult to reverse. So what I find very interesting is that there is this reluctance across the board to simply say, leave, and to leave the institution behind, and to recognize that we have much to gain from a return to what used to be called in the UK civil liberty. And the point about the language of rights is correct. We've allowed the surrender of the discussion around freedom to move from civil liberty, the idea from the English common law that the law will not trespass over a particular line, that there are certain things that the law should not do, that there is a certain space of public life that should be not subject to regulation or external power. And we've allowed that to be replaced with the language of rights, which is a language which encourages the juridification of our relationships. It encourages us to see politics in the language of law. And so my question to leave you with is, why is there this impulse across the board to defend something that's not worth defending? And in many ways, a lot of the remarks in this room remind me of the arguments made by the Liberals in the UK, who say, well, if we leave the European Court of Human Rights, it's going to take us straight back to the 1930s, as Jacob hinted at in his opening remarks. I don't believe that. I believe we can build a culture of political freedom which is actually far more resilient to that currently being offered by the European Court. So rather than reclaim it, we must leave it.
Thank you. Right, so before I invite you to join us for a little drink and to carry on the conversation, I've got three important things I need to tell you about. The first is, as I mentioned in the opening, if some of the legal terminology flew over your head a little bit, or if you just want a definitive statement of how it is that the ECHR, the court, the convention, has definitively trespassed over democratic rights and stopped a serious conversation and action on migration, we have a paper out on that today that you can get on our website, and I recommend you read it. And if you disagree with us, read it too and tell me what you think. So that's number one. Number two, if you're visiting us for the first time at MCC Brussels, your first event with us, you're very, very welcome. We are running a program of events throughout the year, but also we're very, very active on social media. We've got a great YouTube channel where you can check out more things by us, and we're always releasing new reports and new interventions that are highlighting what's going on across the continent and our particular the take on it. And we hope that you'll join us in this effort that we're still engaged in to build a space in Brussels where you can have open and frank discussions. And then finally, I wanted to tell you about a very important event that we've just announced that is called the Battle for the Soul of Europe. You should have a leaflet on your chair about it. It's going to be our major flagship event, our flagship conference. It's going to take place on the 3rd and 4th of December this year. We're in the process of confirming some really, really special, really exciting speakers for you, but it's going to be what we hope is a kind of landmark event here in Brussels that says that the big questions that we're fighting over, legal questions, political questions, cultural questions, that it's time to bring a lot of those to a head and really chart out an alternative vision for what is or what ought to be the soul of this great continent. So we hope you'll join us there, and if you're interested in hearing more or being involved in that event, you should speak to my colleague Tony, who made the comment earlier from the floor, but most of you will know him. But for now, I just want to say thank you so much for joining us, and please come join us for a drink.